court helicopter explainer, where we are dealing with a question about instant fines. NTSA issued a circular and they started implementing instant fines. Many Kenyans were fined. You are driving to take a patient to hospital, you get an instant fine. The roads are not marked. Several issues were done. We went to court, and the court ordered that that is illegal and suspended that implementation. Today, the NTSA has withdrawn their notice and said they want to comply with Section 117 of the Traffic Act. Their argument is that Kenyans don't know and Kenyans don't understand. Why will NTSA say Kenyans don't know and Kenyans don't understand? Court helicopter brings you verbatim what Section 117 of the Traffic Act talks about, so that NTSA will not hoodwink you and nobody will say that you don't know that section. Section 117 says minor traffic offenses. 1. The Cabinet Secretary may prescribe a schedule of minor traffic offenses which may be dealt with and prosecuted in accordance with the provisions of this section, and may, for the purpose of this section, prescribe a statutory maximum penalty which shall not exceed the penalty prescribed for such offences by this Act, for any of the scheduled minor offences to be so dealt with and prosecuted. So the minister has already prescribed by law, court helicopter explainer dealt with what are prescribed as minor traffic offences. That one has been done. Number 2, B, a form of police notification of traffic offences for use under this section. There needs to be a form to be made by the Inspector General of Police. We shall deal with that. That form has not been prescribed. 2, subject to this section, any statutory maximum penalty prescribed under subsection 1 shall, notwithstanding that any other penalty may be prescribed in this Act, have effect for offences with under this section. So, in section 2, the statutory provisions, the statutory fines provided have already been put by the Inspector General and Parliament. Number 3, where you need to understand very well, it says, notwithstanding any provision containing this or any other act, and I move, it shall be lawful for any police officer to serve either personally or by affixing the same prominently to the vehicle concerned or through the use of electronic or mobile communication technology upon the owner or the person in charge of the vehicle. So, under section, that is section part 3, it says that police notification shall be served either personally or it will be affixed at the windscreen of your car or by use of a text message. So that text message that we are receiving is not illegal. That text message is legal. But that proviso says it shall be served only by a police officer, not an NTSA officer. The police officers are under the command of the Inspector General of Police. Once you have been served, what happens? Such a person, once you have been notified, that person can either pay the fine or attend court to answer to such charge or charges. After you have been served, you can opt to pay the fine or opt to go to court where you have you are supposed to appear. The notice, if it is digital, the law says you must be served within 48 hours. If it is by text, Section 3 talks about within 48 hours. If it is a physical notification, you are supposed to be served within 7 days. Subsection 4 says, such notification as aforesaid shall for all purposes be regarded as a summon issued under the Criminal Procedure Code. This is not a sentence. The notification by text message, the notification personally, or the notification by putting on the windscreen is a summon. The meaning of a summon is provided for in the Criminal Procedure Code. What does it mean? You have been called to come to court. It's not a judgment. So that text message is to call you to go to court. It says, once you have gotten that summon on your knee, it says, provided that the person served with the notification shall not be obliged to attend court in answer to the charge if he has pleaded guilty in writing and sent the notification together with the amount of the statutory maximum penalty or penalties for the offense or offenses to which he has pleaded guilty by prepaid registered post or by hand to the court indicated in the notification, so that it reaches in court within the time indicated in the notification. What does 4 say? After you have been served with summons and you say you don't want to go to court, you will pay the fine. Once you pay that fine, you will then plead guilty. After you pleaded guilty, you will give reasons why you are pleading guilty. So if the text message is taken to be a summon, then you are supposed first, the text message is supposed to tell you, Dunstan Omari, you are found over speeding on Mombasa Road. You did 85 kilometers instead of 30. Do you plead guilty or not guilty? Then you confirm with your message that yes, I plead guilty. Then you are sent another message that says, then if you are pleaded guilty, pay the fine of 5,000 shillings. You pay 5,000 shillings. The third stage should be, after you are paid, you give reasons why you are over speeding. Mitigation. You write on your text message, sorry, I was running because there were thugs following me. I was over speeding because I was taking my wife to hospital. I was over speeding because I was rushing to give blood donation to a patient who was dying. After these 3 stages, then this now communication is presented before the prosecutor. The prosecutor files the charges before the court. The court looks at whether you pleaded guilty and whether you are paid the statutory mandatory fine. After you are paid the mandatory fine, the court looks at the mitigation. If the court finds that the reasons are justified and you paid the maximum, the court can reduce that to, if you paid 10,000, the court can reduce to 2,000, or the court can forgive you, or the court can uphold the amount that you had paid. But if you have paid the maximum, the court will order a refund. That is what the law talks about it. Suppose you don't want to plead guilty. It moves on to say, if you are not ready to plead guilty, you will appear in Section D before a court of law. The charges will be read. You will plead not guilty. You will defend yourself. The court will find you. Witnesses will be called. And that speed limit that you exceeded will be brought by that gadget, and the court will be shown how you have speeded. Then you'll be fined, and once you're fined, the fine goes to the account of judiciary. 7. If, that is in 6, it says if the person served is not the registered, is not the driver. Section 6 talks about if you are the owner of the vehicle and you have your driver has overspeeded, but the instant fine comes to you, then it says if any person served with a notification under this section fails to comply with such notification, the person to be liable for the offense shall be the registered owner of the vehicle. So the registered owner, if it is a person or if it is a company, the registered owner shall be held liable. Subsection 7. A copy of the notification shall be placed before the court by which the charge is to be dealt with at the fixed time for the attendance of the accused person to answer the charge, and unless the court otherwise directs. So the charge sheet must be taken to court for you to plead. Whether you have agreed and paid the fine, that must be taken to court for the court to enter a case number to be opened and a plea of guilt be entered and a conviction and a fine be imposed. So that is section 7. Section 8, it is saying if any person having been served with a notification issued under this section fails either to attend the court on the day and a time specified, a warrant of arrest will be issued. If you fail to appear in court, a warrant of arrest will be issued. And if you are convicted, it says, one will be found guilty of an offense and liable forthwith by an order of the court on first conviction. If it will be your first conviction, to a fine of an amount equivalent to 10 times the maximum statutory penalty for the offense which you are offended. If your fine was 10,000, that is the maximum. If you are arrested, you will pay 100,000 shillings. Mark my words. Section 7 makes it that if you jump to go to court, you will be given 10 times the offense that you are supposed to pay. Then 2, if the offense relates to an amount equivalent to 20 times of the penalty for a second and subsequent conviction. If the first time you escape and you are arrested, you will be fined 10 times. If it is the second time, you will be fined 20 times. So if the maximum fine is 10,000, the first conviction is 100,000. If you again do the same offense, you will now be fined 200,000. If the fine was 100,000, you escape, you will pay the first conviction 1 million shillings. If you repeat the second time, the fine will be 2 million shillings. Mark this, how serious this offense is. Then we have, if you are a person, the police have fixed that notice on a windscreen, you go and pick that and run away, or deface it. If you are found, you will, and this is the first conviction, you'll fine an equivalent of 10 times that amount of money that the fine was to be. If it is the second conviction, you pay 20 times that amount of money. If you find you are the vehicle owner, this is section 10, you find they have put there a notice, it has rained, you can't read, you can't see what it is. What does the law say? In section 10, you will go to the nearest police station and report there and find the problem. And if you don't go and report, if you are arrested, you'll be fined Kenya shillings 100,000 shillings. So stop saying gari ilinyeshewa na hiyo kitu ikaanguka chini ikaharibika. That is your problem. You must go to the nearest police station. If you don't go, a fine of 100,000 shillings. Then we have what you call section 117B, preparation for summary document. It says the Inspector General of the police shall cause to be prepared that document. Remember, we told you under Article 244 and 245, the office of the Inspector General is a constitutional office with a mandate to investigate. A traffic offense is an investigation. So, NTSA cannot investigate a traffic offense. Lastly, the officer commanding police division to be in charge of traffic matters. Section 117C. It says, in each police division, the officer commanding police division shall be responsible for traffic matters within the division, and all police officers shall be responsible for the traffic matters. So, where does NTSA come in? NTSA is not the Inspector General of Police. The Inspector General of Police is the one in command of all the police officers. So now, Court Helicopter has explained to you that the withdrawal of this notice and to realign it with this Traffic Act, below the Traffic Act must be amended. It must go to Parliament to amend, to change and put it that NTSA can institute instant fines. Court Helicopter is not against the institution of instant fines. Globally, all developed countries, globally, they have implemented the instant fine approach. The problem with this is that the citizens were never involved, public participation was never involved, this law was not amended because this law must be amended to give NTSA the legal powers to do that. This law must be amended because every fine goes to the judiciary, and that is why you have heard that every notification must be taken to court, and the court gives it a traffic case number, and the fine is registered. Wakili Danstan Omari, always ready and willing to bring it to you as it unfolds. Thank you very much.